Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, and thank you for stopping by. All right, guys, it is time to get back into the 2A news, back into the 2A advocacy, because we have got a mission here. We are going to pass the blessing of the Second Amendment along to the next generation. And the content that I'm bringing to you on this Labor Day morning, I am so amped to bring you because we have another instance of 18 to 20-year-olds in a different state, in a different part of the country, breaking through the barrier that is imposed upon them unconstitutionally. This is a big deal. We've had Texas last week, Virginia last year, Florida the week before Texas. This is starting to become a thing, and I bet that you're going to see 18 to 20-year-olds firearm rights at the Supreme Court pretty soon. Can't say when, but I have a good suspicion that that's in the direction. Now, everything is linked in the description box below. I cannot wait to hear what you guys think of this one, but let's dive into Minnesota because this, like I said, this is a big deal, guys. National groups intervene in federal suit over Minnesota's age limit for carrying handguns. Plaintiffs want to strike down ban on handgun carry permits for adults younger than 21. This came out yesterday. Does this strike any chords? Like I mentioned in the intro, last year we had Virginia where the judge literally said you can't make an entire class of people second-class citizens. Texas last week, Florida the week before Texas. Then you have Minnesota now. Guys, if you're not seeing the way that this is funneling up, and you might recall some of the players here because 3 letters, baby, FPC. All right, let's keep going. A federal lawsuit challenging Minnesota's age limit for permits to carry handguns in public is attracting intervention from national gun safety advocacy groups ahead of key court hearing next month in St. Paul. Of course, because Everytown is even making an appearance because they see the writing on the wall as well. The funny part here is Bruin is only buttressing the arguments for 18 to 20-year-olds to have their firearm rights. They can vote, they can be in the military, why can't they have their Second Amendment rights? It doesn't make sense on its face. But don't worry, I'm going to show you some quotes from Everytown and the state of Minnesota because they are trying their hardest, but I think it is a feeble attempt at some shenanigans. But let's keep going. Quote, this is from the actual plaintiffs. They can vote, enter contracts, and get married. They can join the military. In fact, they can be conscripted to fight and die for their country. And as adults, there are no parents or other legal guardians generally responsible for their care and protection, wrote David Thompson, a Washington, D.C. based attorney representing the plaintiffs. In a recent memo to the court, quote, yet, the Minnesota law challenged in this case categorically bars them from carrying a handgun in public for self-defense as other adult Americans have the undisputed right to do. That is really well worded because it lays it out exactly as it is. You can have certain people have rights, but certain other people can't have rights. That is a problem. Knock, knock. Hey, SCOTUS, got another one for you. All right, check this out. Those suing over what they're labeling as Minnesota's carry ban argue that Minnesota's age limit for the permits violates the Second Amendment rights of 18 to 20-year-old adults. It 100% does. There's no way around it. You're telling legal adults that they cannot partake in Second Amendment rights that are granted to them in the bill or protected in the Bill of Rights because they have a higher propensity for impulsive behavior. So then that argument, they can't have any type of adult privileges. You can't drive a car. You can't, join the military. You can't be married. You can't enter legal contracts because you have the possibility for impulsive nature. It doesn't make sense on any level, but let's keep going because this is where the Minnesota attorneys start to try to twist Bruin. Check this out. Minnesota's attorneys, meanwhile, counter that the state is justified in creating such a restriction. They point to data suggesting those in that age group pose a higher risk of violence with firearms, while other arguments cite high-profile mass situations involving gunmen in that age range. So, because other people have exhibited bad behaviors, you can't have your rights. Is that at all reminiscent of a main tenet of a gun control argument that we're hearing consistently? Well, criminals use guns for bad things, so therefore we should curtail all gun rights for all Americans. We should pass an assault weapons ban of 2022. We should pass some more red flag funding because certain people do bad things, so therefore everyone can't. It's not the way this works. This is a Second Amendment right. This is not a Second Amendment recommendation. But let's keep going because Everytown just got to get in here. They are joined in their suit by the Minnesota Gun Owners Caucus, the Second Amendment Foundation, and Firearms Policy Coalition. They are suing Harrington, which is the city, Mille Lacs County Sheriff Don Large, Douglas County Sheriff Troy Wilberson, and Washington County Sheriff Dan Starry. So they're going after everybody. National groups are getting behind this because if you recall, FPC was involved in the Texas suit, the exact same thing, 18 to 20-year-olds. But listen to the assistant AG from Minnesota. This is actually the reason they're arguing, and then I'm going to show you Everytown because that one is Prutzman, who is the assistant AG, added that the new Supreme Court ruling did not establish 18 to 20-year-olds as part of the people. So let's just pause there for a second. The Assistant Attorney General of Minnesota is saying that, well, 18 to 20-year-olds, they're not part of the people. So can they take part in national elections, which represented by the people? Because that argument is really dumb. Let's continue. To which the Second Amendment applies. Historically, she added, those in that age group were legally minors when the Second and 14th Amendments were adopted. She also argued that laws governing militias underscored that those younger than 21 did not have independent rights to carry firearms and that many laws requiring guardians or parents to procure them. Understand what they're arguing here. They're actually arguing and saying, like, well, they were minors when the Second Amendment and the 14th Amendment were ratified. Okay, well, if you're going with that perspective, that means the entire age group of 18 to 20 can't be conscripted into the military, can't join the military, can't get married, they can't have ownership, they can't own, vote? Yeah, good luck, by the way, because one of the main key demographic voting blocks for Democrats nationally is 18 to 20-year-olds. So you think that one's going to go away? Not likely. But a good video on rights growing wouldn't be complete without Everytown for USA jumping in here, and listen to how they try to satisfy Bruin with this. This is ridiculous. Everytown urged the judge to consider the wealth of restrictions on keeping and bearing arms among adults younger than 21 that dated from the second half of the 19th century. So they're trying to build in from the Bruin decision that history, text, and tradition. The only problem is Thomas didn't say from the early 19th century or late 19th century, which would be 1850 to 1900. We're talking about when the laws were ratified, not 1850 to 1900 when all the progressive era started. And that's what I've got for you guys. Hopefully this started off your Labor Day ride. I think this is a celebration, and I cannot wait to hear what you guys think in the comments field below. Thank you so much for watching, and I'll see you tonight at the 9 p.m. segment. I'm Braden. See you later.